So you might be wondering, what is a special needs trust? Who needs a special needs trust? What are the different types of special needs trusts? Who can help you create one? In this video, I'm going to be talking about all of these things, all about special needs trusts. So you may have a child with special needs and you're worried what will happen when you die and your child inherits the money that you're leaving for them. Because that money has to last for the rest of their lifetime. It needs to protect them and provide for everything they need, since they probably won't have a substantial income coming in. So in this situation, I think a special needs trust is key. Okay, well, first of all, what is a trust? A trust is an agreement that you set up between the person setting it up, which is typically you, the parent, and the person managing the trust for the benefit of the beneficiary. So in this case, the beneficiary is your child. So it's an agreement you're setting up to provide for your child. And what a special needs trust really needs to say is that everything's available for the child after public benefits is being used. Okay? And the child cannot manage the money. It doesn't count as their money. They can't access the money. They can't demand it. And because it's not their money, it doesn't count as their money for public benefits purposes. So I want to pause for a second and actually explain what are public benefits, because that's really related to this discussion. So if you have a child who just turned 18 perhaps, and now all of a sudden they're an adult, which is really funny for any 18-year-old nowadays, right? But they become an adult. Now your money is not attributable to them, so they become poor. They have under $2,000 of countable assets, and now they can qualify for an income stream and health insurance. These are the two things that the government typically provides to someone if they're not able to work and support themselves and get their own income stream and health insurance. All right, so I've prepared a handy dandy chart that I want us to look at. Okay, so in the public benefits world, there's really two different types of public benefits. There's needs-based public benefits, which means you need it because you're poor. And then there's entitlement-based public benefits, which means somebody paid into the system, whether you or your child, and so you're entitled to these benefits. It doesn't matter what type of resources you have. So for the resources where it's needs-based, you have to have under $2,000 of countable assets. Now, there's something going through Congress right now to increase that amount to about $8,000, and I really hope it passes. But as of this recording, it's just $2,000, which is really nothing. Okay, so if you have under $2,000, you can qualify for an income stream. And this is if you're disabled and you can't work because of your disability. You can qualify for an income stream called Supplemental Security Income, or SSI. And this guarantees an income of up to about $1,000 a month. It's intended to supplement any income you're already receiving from the government or from any other sources. Okay, and if you get even $1 of SSI, you automatically qualify for Medi-Cal, which is California's version of the federal Medicaid system. So here we have Medi-Cal. Now, also included in Medi-Cal is something called in-home support services. And this is a really important benefit that your child might receive, where somebody's actually being paid to provide services to your child in the house. And sometimes that can even be the parent themselves. All right. Now, the rules on Medi-Cal just changed, and I want to talk about that for a second. Okay, so it's really exciting. As of this recording, the rule just changed, so it's not a $2,000 limit for Medi-Cal. In fact, it's gone up to $130,000. And I've actually done a video on this, so I encourage you to watch it. But it goes also in January of 2024, the resource limit is going to be eliminated completely. So they're not going to look to see, do you have $2,000 in your bank account? Do you have $130,000? No, just about everybody in California is going to qualify for Medi-Cal, which I think is very, very exciting. However, SSI, Supplemental Security Income, still has a limit of $2,000. So that means if your child is receiving SSI, for example, and then they receive their inheritance, that might bump them off their public benefits. Okay, so that's when we would need to create a special needs trust. Now, I want to also mention the other two benefits here. We have the the entitlement-based benefits. Okay, so that's if somebody's working, like you or I are working for a while and then we become disabled. We can get an income stream called SSDI, Supplemental Security Disability Insurance, and that's really based on how much we worked, right? So we get this income stream, and then after 2 years, we actually qualify for Medicare. So somebody who's disabled doesn't have to be age 65 to get Medicare. If they're getting SSDI, then after 2 years, it actually turns out more like 29 months, but pretty much after 2 years, they can get Medicare, which is a really good health insurance program. And some people actually get both. We call them Medi-Medi, right? They get Medi-Cal and Medicare, which I think can be very beneficial because the two programs cover different things. Now, if you have recently retired and you have a child who is disabled before age 21, they can qualify for CDB benefits, child disability benefits. And that's kind of under the SSDI umbrella. And CDB benefits are typically half of whatever you're receiving at the same time that you're receiving it. And then when you die, the child receives up to 3/4. So in certain situations, you can see that you might have a child who is bumped off of their public benefits if they receive an inheritance outright. Or that child just may not be ready to inherit money or manage money, or they'll never be able to manage money. So in those situations, we create something called a special needs trust. So as I mentioned, this is a trust. It's where you set up a trust, or anybody can. Actually, it doesn't have to be a parent. It can be a grandparent, it can be a friend, it could be a trusted neighbor. Sets up a trust for the child's the beneficiary, and the child can't access the money, so it doesn't count as the child's money for public benefit. So there could be $1 million, $5 million in a special needs trust, and the child still continues to qualify for SSI. Now, I should mention, in every other state in this country, they have not changed the eligibility rules for what they call Medicaid. Medi-Cal is California's cutesy name for Medicaid, but they haven't changed the rules in other states. So if your child lives in a different state, or they might be moving to that state, then they'll also need a special needs trust to protect their public benefits if they're in that state. So there's different situations where you need this type of trust. Okay, so there's 3 main types of special needs trusts, and you might be wondering, which type do I need? Do I just choose it out of the blue? Well, no, let's explain it. So the type that I've been talking about so far, where somebody inherits money from a loved one or from a friend, that type of trust is typically called a third-party special needs trust, because it's the third party's money that's going into the trust. So with a third-party special needs trust, it's somebody else's money that's going into the trust for the disabled person. That's a third party in relation to the disabled person. Okay, now contrast that with a first party special needs trust, and that's where the disabled person received their own money. Let's say an inheritance was left directly to the disabled person, or they worked for a while and then they became disabled, or they were in a lawsuit and they got a settlement amount. In those cases, it's considered the disabled person's own money, and they need a first party special needs trust to hold that money. Okay, the third type of special needs trust is called a pooled trust, a pooled special needs trust. And this is really a trust that's set up by a nonprofit organization. And the idea is they pool together a lot of smaller special needs trusts, and then they have somebody to manage it, and they have ways to make distributions. They have something called a master agreement, and you sign in, and then you do a joinder agreement. So it's a different way of doing things. And this is appropriate in certain situations. So I want to talk about the difference between the different trusts and which type you might need. All right. I think the third-party special needs trust is the best, because upon the disabled person's death, all the money goes wherever the trust says it goes. So if the trust says it goes to their sibling or to other family members or to charity, it goes straight there. Medi-Cal does not get their money back. There's no reimbursement claim. But compare that to a first-party special needs trust, which does require a Medi-Cal reimbursement claim. So not all trusts do, but the first party special needs trust does. Also, the first party special needs trust needs to be set up and funded before the disabled person turns 65. Now, what if the disabled person has received their inheritance or they got into the car accident after age 65? Then they would need a pooled special needs trust, the third type that we're talking about. Another difference is that a first-party special needs trust needs to be set up by the beneficiary themselves, a parent, a grandparent, or the court. Nobody else can't. So auntie can't set up a first-party special needs trust, the neighbor cannot. It has to be those types of people, or you have to go to court. Whereas a third-party special needs trust can be set up by just about anybody. In fact, anybody except for the disabled person or their spouse. So here's another chart that I created, and you can pause this if you want and take a look so you can see the differences between the different types of special needs trusts. So here we have the third-party special needs trust. Anyone can set it up for that person. The funds come from anyone but the disabled person. And on their death, it goes wherever the trust says. So you setting up the trust, you get to choose where do things go, and you specify that in the trust so that there's no question, there's no arguing upon the disabled person's death. Okay? Compare that to a first-party special needs trust. We also call this, by the way, a D4A special needs trust because it's from the whole long probate code 42 USC and then the last bit is D4A. All right, we're kind of nerds. We're not very creative in this field. So if you set up a first-party special needs trust, it's only the disabled person's funds, and the disabled person has to be under age 65 when those funds go into the trust. And again, I mentioned the types of the identities, the relationships of the people who can set it up, and you have a Medi-Cal payback. All right, so the last one, a pooled special needs trust, it receives the disabled person's funds, just like the first-party special needs trust. It can also be established by any of these people, okay, through the joinder agreement. And then the distribution, you really need to talk to the nonprofit to see where does money go upon their death. Sometimes it goes to the nonprofit, sometimes it goes to Medi-Cal. So you would need to work that out with them. So I just want to pause and point out that we've already done a pretty deep dive into a lot of this materials, and I know it because I specialize in this field. I specialize in special needs trusts. So I suggest you really find an attorney that specializes as well. Not all estate planners do special needs planning. In fact, most do not. However, they might have the language to put the trust in, but they really don't understand the ins and outs, just like I've just explained. So I suggest you watch this video on how to hire a special needs attorney. Okay, so now that you know which type of special needs trust you need to set up and whether you might need a special needs trust, now you need to think about what decisions to make. And it's really good to think through these things before you meet with the attorney, because these are the questions, if we were to meet, for example, I would be asking you. So the first question, the most important one, is how to choose a successor trustee. So when you set it up, you guys are the ones managing the special needs trust, right? The parents typically, or another trusted loved one. But while you're alive, you really are their special needs trust. You're providing everything that they need. So you don't need to fund or put money into the special needs trust until you're gone. Then it becomes like the surrogate financial you. Somebody who would make all the financial decisions about your child for their benefit. So there's different types of trustees out there who you could name. You could name a family member or a friend. You could name a professional, which is often what I recommend. You could name a nonprofit organization. And I actually have a video on how to choose a successor trustee, and I've gone into a lot of depth on this. So I suggest you watch that video. And I think that this is the most important decision you'll have to make, and a lot of times it's the hardest decision. People can agonize over this for weeks and even months. Who's really the best choice? Because a trust can be perfectly drafted, but if you don't choose the right trustee, that can break the trust, really. So I encourage you to really dive into this even before you come into an estate planning attorney so you have a better idea of your different options. Also in that video, I talk about the concept of trust protectors, which is where you can name a family member to oversee the trustee. And I think that can be a very good setup if you have trusted family members, but those family members want to live their own best lives, or they're very busy and they can't manage the trust, or it's just a better choice not to have them manage it. Another decision to make is how to fund your trust. What money should go into the trust? So you can name the trust, for example, as the beneficiary of a retirement account. You can name the trust as the beneficiary of a life insurance policy. I have one wonderful client who recently has set up a special needs trust. She doesn't have a lot of money, but she has a disabled child and she got a life insurance policy to fund that special needs trust. Of course, the assets in your revocable trust, and you should have a revocable trust too, the assets in your revocable trust, which would typically be property, investments, checking and savings accounts, those can also go to the special needs trust. And as I mentioned, this should happen typically after you're gone. Another thing to think about, and I know this is difficult to think about as a parent, but what happens after your child is gone? Okay, where does the money go to? Do you want it to go to the other child if you have more than one child, right? Maybe your disabled child will still be able to have children. Do you want it to go to them? If you don't have any more descendants, where should the money go to? We often call that the Titanic. If everybody's on a trip and the boat goes down. And I know as a parent of two kids, my older son's turning 10 and my younger one's 8. And of course I assume, knock on wood, right, that they're going to survive me. But, you know, as estate planning attorneys, we're paid to worry for you. Okay, so we do need to map that all out, and upon the death of the disabled person, where does the money go? Just like I mentioned, we want it to go to someone else and have them clearly named so there's no fights. We want to name somebody who's younger, right? So don't just name your siblings because they might also be deceased. And then we have to go to court. And let me tell you, even though I'm an attorney, I hate going to court. So all of this planning that we're talking about actually takes place outside the court system. So we avoid probate, which is fabulous. Another thing people often ask me about is, should I set up the special needs trust as a standalone document, or should it be part of my revocable trust? And I just about always suggest setting it up as a standalone document, okay? Most attorneys draft it as what we call a testamentary special needs trust, which is part of the overall estate plan. But there's a couple problems with that. One problem is, what if you have a grandparent who wants to leave money to that special needs trust? Well, as a testamentary one, as part of your revocable trust, that trust doesn't spring into being until both parents are gone. And hopefully the grandparent's gone before the parents. Usually that's the order that it goes. So a standalone special needs trust can be funded at any time by any person, so it's a lot more flexible. The second reason, which I think is even more important, is upon the funding of the special needs trust, public benefits, Social Security Administration wants to look over the trust and make sure it's a valid special needs trust. And if it's part of a long revocable trust, then they're going to get really confused. They don't specialize in reviewing special needs trusts. So sometimes they even make you cut and paste it, right? You might have who's the trustee in Article 2, and then who's the successor trustee in Article 7, and it's all jumbled around the revocable trust. They can't follow it. But if you have a standalone special needs trust, it's really easy for them to review. So I just about always do standalone special needs trust. There's a few times that you'll want to incorporate it into the testamentary special needs trust, but they're few and far between. Now, to choose a special needs trust attorney to help you actually create your special needs trust, I've done a video just on that, so please watch it right here.